All right. Guys, don't go anywhere. Let's bring in Jacob Frenkel, a former attorney with the DOJ, to shed some light on this from a legal perspective. Jacob, it's always good to have you. Thanks for joining us.
Thank you for the opportunity.
How are people supposed to think that this is a situation where someone is guilty but not guilty enough?
Well, I think the answer to that is we have to give a lot of deference to the director of the FBI, Mr. Comey, who is an experienced prosecutor as well. What I found a little bit more troubling is the continued and repeated reference to intent. They found no evidence of intent. There was one other point that he made during the press conference that I found a little bit troubling, which was that they could not find any other such case historically. As to the issue of intent, he did describe what I would call a significant pattern, a significant practice, that there is a substitute in the law for criminal intent. In lay terms, it's the ostrich head in the sand. In legal terms, it's called deliberate ignorance or willful blindness or conscious avoidance. That is a point that he did not address, and it certainly sounds like the type of situation that a reasonable prosecutor in other circumstances involving somebody who is not the Secretary of State may well have considered finding that there is a legal substitute for criminal intent. As to cannot find such a case historically, that's sort of, to me, flies somewhat in the face of a lot of other aggressive prosecution theories that the Department of Justice always does not hesitate to reach out and bring. I mean, if we were to go back 10 years, we could say the exact same thing about the Foreign Corrupt Practices Act. Look around now. We've gone, corporations are prosecuted left and right for violations of the Foreign Corrupt Practices Act. So are individuals. So this notion of the absence of there being meaningful precedent in prosecutions, to me, rings somewhat hollow. Do I believe this was an independent investigation? Yes, I do. Do I think we can give deference to Director Comey and his team? Yes, I do. But I still think there are a lot of significant questions that are entirely unanswered.
Well, Mr. Frankel, from my hearing, Comey seemed to be saying there was no evidence of a cover-up here. There was no evidence that there was malicious intent, that that Hillary Clinton and her State Department were trying to undermine the interests of the United States, and therefore we wouldn't recommend that the DOJ bring charges. But are you saying that the pattern of carelessness was such that you would think that that amounts to criminal intent, even if it's not exact? The pattern was so careless that they must have known that this was endangering the interest of the United States.
Well, again, I go back to, I have great respect for Jim Comey and always give deference to the integrity of the investigation. So, that still is sort of my, I hate to say it, my fallback here. But I think we have to look at what is the standard. There is a statute, Title 18 in the Criminal Code, Section 1924. In all of my years of doing commentary for CNBC, I'm rarely referencing a statute. It is the unauthorized removal and retention of classified documents or material. There is an intent component to that statute, but it's not about whether there's an intent to deceive the government, or to put the U.S. government or its materials at risk. It talks about knowingly removing documents and materials without authority and with the intent to retain such documents or materials at an unauthorized location. And I can't see how a personal email server of the Secretary of State, for somebody who had been married to the President of the United States, would be anything other than an unauthorized location. Those are the principles with which I am struggling.
So, John, Jacob, one follow here, Jacob. It sounds like you're arguing that there is room for justice to be more aggressive than perhaps Comey suggested.
I think that's a fair statement. I think the Department of Justice, senior prosecutors certainly can review this, and I think there is a basis for the Department of Justice to come to a different conclusion.
John?
Carl, I was just going to say, on Jacob Frankel's point, for a good chunk of that presentation by James Comey, you could have thought that he was building up to a willful negligence kind of charge. You know, yes, it did not match the circumstances of, say, David Petraeus, who knowingly gave classified information to his mistress, and that case ended up in charges. But he described at the beginning the potential for a negligence. I think Jacob Frankel can correct me. I think he described that as a misdemeanor charge, but it for some of the presentation like that's where he was going. In the end, he did not.
I would, and if I may just very briefly, I would agree that I think there is a statute that is potentially applicable, and that using the legal substitutes the Department of Justice uses all the time for criminal intent. And again, depending on which jurisdiction you're in, if that is deliberate ignorance, willful blindness, or conscious avoidance, those are substitutes in the law for criminal intent. And I think I would agree with you. That could have been the start. That could have been a press conference that was laying out the basis for. We could not find affirmative criminal intent, but there was sufficient evidence here from which you could make a circumstantial case and make a case that there was a substitute in the law for criminal intent in terms of, again, deliberate ignorance. Go ahead.